Good morning. Is Ms. Cowlow?
Ms. Callow, yes.
Callow.
Good morning. May it please the Court, Ellen Callow on behalf of the Sheriff of Suffolk County. Leonard Gibson did not sustain his injuries in a scuffle. Leonard Gibson, a 19-year-old detainee with Tourette's syndrome, was attacked and beaten in his cell in the medical unit at the Nashua Street Jail. Yes, Your Honor.
Your brief says several times about the Tourette's syndrome, and I have no doubt that that's true, but that didn't seem to ever come up in the arbitrator's award or decision or in the appeals court, either of the two decisions. So is that really part of the record? I mean, there's no issue. It didn't seem like anybody was sort of dealing with this was a sort of disability issue. I appreciate the fact that he was on the medical part of the jail, but that the Tourette's syndrome just didn't seem to be a fact.
I suggest it's a fact insofar as Mr. Gibson himself, and the arbitrator recounts it, I believe, on page 24 or 25 of the record, in which Mr. Gibson says, "You guys are always making fun of me."
Right, I remember that.
And the point being that it may very well have been an impetus for these officers to go in and to beat him and assault him. Certainly, it is not a significant fact in terms of the beating was occasioned by his disability.
Okay.
But to point out certainly that Mr. Gibson, by virtue of his incarceration as well as his condition, as well as any other individual who's incarcerated in a cell, it points out the fact that they are at the mercy of jail officers who essentially control every aspect of their lives. But I think the point that I'm trying to make here to this court is that Gibson was attacked. He was beaten in his cell, in the medical unit, in the jail. Officer Upton witnessed that attack.
And where
He
is
knew
that?
that it happened.
Where is that finding?
Finding,
because there seems to be some dispute about whether the arbitrator actually found that he witnessed the attack.
Didn't he say
And that seems important.
Yeah,
it's significant, yes.
I thought your position in your brief and the finding was not that he actually witnessed it, but he was in a position to do so.
That is what the arbitrator says.
Well, he actually says a little bit more
He
than
says
that.
significantly more. He says significantly more. First of all, he finds that, in fact, Upton opened the cell door to allow the officers to enter. He finds that the officers...
That's not helpful, though. That's not really... That
well,
doesn't...
it's helpful, I would suggest, Your Honor, insofar as...
If you get an order from a superior officer to open the door, what are you going to do?
There's no suggestion that either by the position of the sheriff or the arbitrator that Mr. Upton was complicit in the beating.
Right.
Right, it's only later on.
The point is, with the immediacy, the swiftness with which the beating occurred, the arbitrator concludes that Upton was not at fault for the beating because it happened so quickly and it was unanticipated. It would be meaningless for the arbitrator to make that finding if Mr. Upton did not witness the attack. It would be meaningless for him to find that. He finds that he opens the door.
Why? Because it's conceivable that he could have been responsible for it. So why is it meaningless to make the finding that he wasn't responsible for it?
Well, it's significant.
It's conceivable the whole thing was a conspiracy among the three of them. So why is that finding irrelevant? It's not irrelevant at all, it seems to me.
No, I guess the point that I'm making, and maybe I'm making it inartfully, the point is that Upton opened the door, the officers went in, the attack happened swiftly. The arbitrator does not fault Mr. Upton for stopping it because it happened so quickly. So that the proximity, the timing of it leads to the conclusion that Mr. Upton was right there. I would point out that the cell, the medical unit that Mr. Upton was in charge of was small. There were only 7 cells.
Ms. Cowler, forgive me
Yes.
to interrupt you. Can I ask you a question?
Yes.
If Officer Upton had not witnessed the event, the assault, would he have been required to file a report?
If he knew that officers assaulted an inmate or detainee in his care and custody, he had an obligation to report it.
But so he might have witnessed it, but not. But could he? Was he required to file a report if he heard from a third party, including the victim.
Yes, absolutely.
So the fact that the arbitrator concludes, I should say, that Officer Upton failed to maintain a proper log and file some form of report of an unusual and significant event, i.e. the assault, I cannot conclude from that that Officer Upton witnessed the assault. He could have been informed of that by somebody else.
That is absolutely true.
Now, was there any evidence that anybody informed Officer Upton?
If I may just step back for a moment and kind of respond again to your question, Justice Marshall. The arbitrator determined that an assault happened.
Right.
He determined that Mr. Upton failed to report the assault.
Correct.
Mr. Upton was approximately 15 to 20 feet away from the cell where Mr. Gibson was attacked and beaten. The arbitrator credits, in reaching his conclusion that finding that discipline was appropriate, he credits the testimony of the victim, Leonard Gibson. Leonard Gibson said Upton was present when the attack occurred. The arbitrator credits the testimony of Leonard Gibson and the other inmates in the medical unit, particularly inmate R, who said that when the officers left the cell after the attack, Upton was at the control booth in a position to observe. There is no question that in determining that an assault happened and that Upton failed to report it, the arbitrator relies significantly on the report of the SID, the Sheriff's Investigation Division, the testimony of Leonard Gibson, the victim, and the other inmates.
What was the nature of the assault?
He was beaten and sustained visible physical injuries, trauma, blunt trauma to the head and to the chest area. There was physical evidence of the trauma to Mr. Gibson that was observed by Officer McCullum, who came in on the 11 to 7 shift to relieve Mr. Upton. I would point out that the record is clear. That is the first time that medical attention is summoned for Mr. Gibson. Officer McCullum comes in. He does his cell checks as required, which the arbitrator found that Mr. Upton did not do sufficiently. He sees that Mr. Gibson has injuries to the head, an abrasion. He summons medical attention. The nurse who appears also finds the same traumatic injuries, and he says that they are fresh, moist, with blood.
All these details are very interesting, but isn't the ultimate question, we have arbitration, and we've made the public policy decision that we're going to have arbitration and collective bargaining for public employees, and the arbitrator made his determination. Why should we be upsetting why should a court be substituting its judgment? What 7 people think is important public policy? Why shouldn't, since we have arbitration, why aren't we stuck with what the arbitrator has decided?
Well, in fact, you are stuck,
agreed.
if you will.
The employees have agreed to collective bargaining and arbitration. I mean, that's what they've chosen.
Absolutely, but it's for this court to determine whether or not an arbitrator's award violates public policy to the extent that it must be vacated. And I would suggest that this court's determination and decision in the DeSciullo case, it governs this case. This court should be as outraged as it was with respect to the conduct of Mr. DeSciullo, finding that his conduct violated public policy, as it should be with Mr. Upton. Yes, Your Honor.
Ms. Caldwell, the conduct, and I agree with you to the point that, well, he wasn't the one I mean, he wasn't covering up his own bad acts, he was covering up somebody else's. Doesn't matter a whole lot to me, but the facts of what Mr. DeSciullo did versus Upton, they really are quite distinct, at least, and all I'm going by is reading the court's description in the 2005 case. But I mean, it was a combination of events that seemed to me to be arguably qualitatively worse than certainly quantitatively worse than what Officer Upton was involved in.
I would respectfully disagree, Your Honor. And while Mr. DeSciullo may have engaged in quantitatively more egregious acts, Mr. Upton's conduct was the direct repudiation of his sworn obligation to protect the detainees and inmates committed to his
Not
care
as
and
found
custody.
by the arbitrator, because essentially what the arbitrator found was he didn't log this in.
Well, that's what
And
he was
didn't- and
required
he-
to do.
Right, and but he didn't, but not logging something in and not cooperating with the investigation is different from the type of felonious conduct that was involved in the DeShulo case, the City of Boston case.
No, Your Honor. These are two law enforcement personnel. Both of them committed misconduct that was integral to the performance of their duties.
Right.
Both of them submitted false reports, which I suggest
Right.
is also a criminal offense. Both of them lied to their respective investigators, to the investigators from their respective departments about their own misconduct, and in Mr. Upton's case, the misconduct of others. That is misconduct that violates public policy.
Can I ask you this? Did
Yes,
the
Your Honor.
arbitrator find that, in fact, Mr. Upton filed a false report?
Yes.
Yes.
Which report?
He filed a report when requested by the Sheriff's Investigation Division that stated that the only thing that comes to mind is the supper incident, and then when Mr.
Which was the
Gibson-
fight, which was the argument at supper, which presumably just preceded this.
It was, I don't think I would characterize it as an argument, but in which there were words exchanged, and Mr. Gibson is ordered back to his cell. He complies.
So that's
And
the,
thereafter, and that was it. Mr. Upton, in his report, did not state that he let the officers in. He did not state that there was an assault as found by the arbitrator. He didn't state that Mr. Gibson sustained injuries. I mean, it's a false report when viewed in the context
Okay.
of what the facts are.
He didn't state that the other two officers were there also. Right.
Clearly. And in fact, his failure to maintain the log is part of this.
But did the arbitrator state specifically in what respect the report was false?
No.
And you know, one of the problems with the case is the critical fact that you're asking us to accept is that Gibson saw the beating.
Upton.
Not
Oh,
Gibson.
Or that Upton saw the
Gibson
beating.
certainly saw
He
the
was,
beating.
yes, Gibson saw it. Is that Upton saw the beating. But you said to us that the arbitrator found that it happened, quote, so quickly, from which we can imply that Upton saw it and had no time to intervene, and that the arbitrator also failed to report. Arbitrator found that Upton failed to report the assault, implying that Upton knew about the assault. But the critical fact is, the arbitrator never specifically finds.
But that's true. But the facts that he does find. I mean, if you look at the arbitrator's decision on page 29, he outlines the issues that he needs to wrestle with. Was there an assault? We know he answers that in the affirmative. If so, when does it occur? He states it occurs later on in the opinion, sometime between 5 o'clock and 7 o'clock. The only time where he says that the inmates are at odds with each other is with respect to when it occurred. But he says in any event, whether it occurred at 5, closer in time to the supper incident, or 7 when the sun was going down, in any event, Upton was there in a position to observe, and he credits the testimony of Gibson as corroborated by the other inmates, specifically inmate R.
But Gibson's testimony simply is that he was in a position to see. It doesn't mean that he saw anything.
One can witness an assault of this nature when there is physical force applied sufficient to leave abrasions on one's head and the chest by their ears and by their eyes. He was 15 to 20 feet away in a very small unit. The other inmates testified that they heard sounds.
Is it possible? Can this arbitrator's report decision be reasonably read in such a way that he concludes that Upton was just a lousy employee sitting in a chair, occupying the time needed to collect a paycheck, and did nothing to do his job as he was required to do?
No, Your Honor, and the reason why is that wouldn't be just cause for even a 6-month suspension, much less any sort of discipline. The essence here is that he finds that an assault occurred. He finds that Mr. Upton failed to report the assault. He finds, and he says that Upton doesn't cooperate with the investigation. Judge Billings, when he heard the case in Superior Court, was really a bit more on target. He suggests, or he says, that Upton dissembles. Upton lies. Upton says nothing happened. The tipping point, I would suggest, occurs in the second interview when Mr. Upton is speaking with the investigator, Greg Haw, and Mr. Haw says, look, Mr. Upton, Officer Upton, I recognize that you didn't know it was going to happen. You weren't part of a conspiracy. You still have an opportunity here to tell the truth. Upton leaves the room. He comes back in after conferring with his union representative and says, I have to stand by what I said. It was a lie. It was a lie.
Carlo, could I ask you a somewhat separate question?
Yes.
I am troubled by the arbitrator's footnote. I have an unnumbered, it's page 32 of the record, where he is troubled, or she, I don't know if the arbitrator is
It's a he.
It's a he, is troubled as to why Officer Whitfield, who was, I take it was one of the officers who attacked the inmate, is that correct? Whitfield?
He was, the two individuals who were identified as being the assailants were actually Lieutenant Eric Donnelly and Officer Benson.
Anyways.
There is some involvement by Officer Whitfield, but no discipline was brought against him.
What is the, and what he says is, you know, Whitfield was treated differently, quote, without any explanation, and he then goes on to note that obviously it's not the union's duty to challenge the failure to take action against another union member, and then says, without some explanation, the action or inaction against Whitfield raises a question of disparate treatment. It seems to me that that's a rather unusual statement for an arbitrator to be making. In other words, what the arbitrator is to look at is what is happening in this case and what has happened in other cases where there's been a failure to report, correct?
That's absolutely true, and that is a concern, and that was something that was, that is a concern, because the issue solely before this arbitrator was, did an assault occur, what was Mr. Upton's involvement, and what misconduct, if any, is it established that he engaged in? And the issue before the arbitrator was not what happened to anyone else. I want to get back briefly to a question I think raised by Justice Cowan with respect to, if I may, on the issue of...
I'm afraid,
okay.
Ms. Carney, your time is up.
Thank you very much.
Mr. Pfaff?
Good morning, members of the court. You cannot write down something that you didn't say. You can't.
Well, you can, of course.
Well, but you'd be making it up.
Well, I mean, if you...
see it.
Are you telling me, that, and that's why I asked Ms. Cowlow the question, I mean, if that's the case, and the arbitrator is absolutely dead wrong, and there should be no discipline here.
If, in fact, there was.
If he didn't either see it or was not informed
Or
about
heard
it in
it.
the course of his
But
duty.
he could have been informed about it.
Well, if he didn't see the assault, I would suggest to you he cannot be required to write a report about it.
But then the
Well, then-
arbitrator is absolutely wrong.
What would warrant 6 months suspension if that's the case?
Well, there are other infractions besides not seeing the actual assault that Mr. Upton
What is the
alleged to have
obligation on an officer if somebody reports an assault? Somebody comes up with their head bleeding and says, I've been assaulted.
committed. His obligation is to report that.
Well, why is...
Well, and also to get medical attention, I would
Sure.
assume.
So
Yes,
why?
I'm gonna
So
address that
why?
in a minute. It's a
So
very good
why do you say that if he didn't witness it, he had no obligation to report? Of course, he has an obligation to report.
He has obligation to report if somebody comes to him and tells him, yes. But my point is this. If he did not witness it himself, he has no obligation to write, in fact, that he did witness it. There's not a finding anywhere by the arbitrator, anywhere, that, in fact, Upton witnessed this assault.
But-
This would be a very easy case for everybody if, in fact, there was a finding that he witnessed it. It'd be a
Mr.
very
Glass,
easy case.
what warrants 6 months discipline if he wasn't in a position to or didn't know about it?
Oh, there are other infractions there,
Like
Your Honor.
what
He
would
didn't-
warrant it?
He did not, in his log, indicate that, in fact, other people had come into the unit That's a mistake according to public policy of the sheriff.
That's a
He did-
6-month suspension
Well,
without pay?
there are other things as well.
He didn't
I'm
make
not trying to
20-minute.
bite the hand that's offering me
No,
a
I'm
piece
not
here, but-
offering you anything, so
Okay.
don't worry.
But there are other infractions besides not writing down the assault that he didn't see.
He didn't, he failed
he-
to conduct his rounds.
He didn't do his rounds. He's supposed to do 3 per hour. He's supposed to log in whenever there is inmate movement. He's supposed to log in whenever there are visitors here.
Was he
at the
required to
facility.
investigate if he heard sounds? I mean, why can we not accept that the arbitrator credited the evidence of the other witnesses that they heard?
Well, I'm not so sure if the arbitrator credited those other witnesses. I believe on page 32, what he indicates is that these 2 witnesses said that they saw that. But he doesn't make, as Justice Cordy pointed out, he doesn't make a specific finding that says, I now find that Upton witnessed this assault.
But doesn't it follow, if we're talking about 15 to 20 feet away from the cell, other people report that they heard and saw the beating, that Upton had to have heard? Isn't that a reasonable inference?
You're asking now to look into the arbitrator's decision and extrapolate back and say, this must have happened. B must have happened because we begin with A and the arbitrator went to C. Therefore, B must have happened. Yet the arbitrator never makes a finding that B occurred, i.e., that Upton witnessed the assault. Respectfully, Your Honor, you can't stand here as
Yeah, but he did
as
make the
reviewing
finding
court.
about the size of this, the area, 15 to 20 feet, didn't he?
The area, the distance between?
Yeah.
I don't believe he did. I believe the finding he made was there weren't many of them. Had there been more, I think this would be an easier case. The findings that he made were this attack or this assault took place someplace between 5 and 7 p.m. The other finding that he made was that for 35 minutes during that 120-minute period, Upton wasn't there. Upton was off for some reason. Upton didn't record the fact. There's another mistake, Justice Bodford. He did not record the fact that he had actually left the area. The 5:30 to 6:05 is when he is not in the area on the floor anywhere around the victim's cell. So there's a 35-minute gap there in
Mr.
which
Pfaff.
anything could have happened.
Mr. Pfaff, could I just turn your attention to the appeals court's decision, which we sent back for them to consider in light of our decision. The appeals court said the sheriff's investigation also disclosed that another correction officer, Mr. Upton, saw some of the salient facts, failed to report the matter to his superior officer, and lied to the investigators in an attempt to cover up the malfeasance. And I'm not asking you to address that, but that's the way they set it up. And then when they consider the Boston police case that we asked them to look at this, what the appeals court conclude is different, and so I'm not getting into a factual dispute, is that in that case, the DeShula case, he was the original perpetrator of bad acts, who then went on to shroud his own misconduct in an extended web of lies. In contrast, Upton's conduct was the result of, and I'm quoting, trying to cover up the misdeeds of his fellow correction officers and not the result of trying to cover up his own misconduct. It seems to me that, assuming that we conclude that is what, in fact, is supported by the arbitrator's record, if somebody who is charged with the safety and protection of people who are in the custody of the sheriff tries to impede the obvious obligation of the sheriff to ensure that inmates are kept safe and secure, that surely cannot be distinguished just because he's trying to cover it up from the bad acts of other officers than the bad acts himself.
The point is well taken, and I'm not here to tell you that there should be some sort of different standard for somebody like Upton, who, if you were to find that that Canavan had said Upton was involved in this conspiracy, his egregiousness, I suggest to you, would not be any different simply because he
So
is
you would
once removed from that situation. I will
So
say.
you would agree with me that the basis on which the appeals court distinguished our ruling in the DeShula case, the Boston police case, cannot withstand scrutiny?
I would agree that there is a distinction made in the DeSulo case because DeSulo was the involved perpetrator, and that if you will, Upton is one step removed because Donnelly and Benson were the alleged beaters of
But the
Gibson.
question
I
is
don't
that-
think that's a distinction.
Is there a
with difference, though.
distinction from DeShula, the Boston police case? Because in that case, several statutes, when read together, the statutes clearly said we don't want felons on the police force, and we could say that's a clearly stated public policy. That's a much stronger statement than there is here. There's no set of statutes or even policy of the sheriff or a set of regulations that we can say was violated here the way statutes were violated in the Boston police case. Isn't
Correct.
that a legal distinction?
Yeah, that is a distinction here, but I thought the question directed to me.
No, I'm just asking.
No, I would agree with your observation, Justice Cohen. I mean, there seems to be more of an egregious involvement here with DeSulio and what he did in terms of making false charges against people, having them arraigned, and then creating perjury on his report. So there is a distinction there between the two. I'd like to get back to what Justice Gordy asked. I believe you asked earlier, was there a specific finding by the arbitrator that Upton falsified his report? The answer to that question is no, there is not. It's on page 32 of the finding. It's the last paragraph before the bullet marked as finding. The statement is this: he being Upton, further did not cooperate with the SID investigation and filed incomplete, misleading, or a false report. No specific finding that he filed a false report. The misleading report might have been the fact that I did not indicate anywhere in my report that people had come in and out of the area. I did not indicate anywhere in my report that I myself left the area. Those matters may lead up to a 6-month suspension. However, under progressive discipline, which is present in the collective bargaining agreement, even a 6-month suspension might be a little too much for those infractions. As I indicated in my brief, Mr. Upton had an impeccable record, but for sick time. There was no indication whatsoever that he had been a disciplinary problem for the department. Again, the 6 questions that Ms. Carlo brought up that the arbitrator posed in his decision, if in fact he had answered all those questions specifically, we might have an easier case to look at. Was there an assault on Gibson? Absolutely. When did it take place? Sometime between 5 and 7, but you can't ignore the specific...
Well, he actually goes on to discuss that and to say it was clearly after, it was after the supper incident, as the sun was going down. So I think the arbitrator is in fact concluding that it was not between the time 5:30 and 6:05.
Respectfully, Your Honor, I don't find that at all. I think that would have been a very easy statement for the arbitrator to make on page 32 of the record in the first full paragraph. It would have been very easy for him, after that analysis, to say, I find that, in fact, this must have taken place not in the time period between 5:30 and 6:05. He didn't make that factual determination. Your review, respectfully,
if there is no evidence that somebody came to him to report it, then there can be no basis for the arbitrator. I mean, you may want the arbitrator to say, I find that, but in fact, his conclusion that he failed to maintain a proper log and file some sort of fault of the assault cannot follow unless the arbitrator has concluded that the assault took place while Mr. Upton was not on a supper break.
I disagree. I think the allegation of not reporting the assault doesn't necessarily mean that Upton witnessed it and didn't report it. There are other aspects of this assault, including the fact that Upton's shift went from 3 p.m. to 11 p.m. If this assault did not happen later than 7 p.m., then during Upton's rounds and his checks of the cell, he should have seen a beaten victim, Gibson. And he should have realized potentially that there was one of the inferences to be drawn from somebody who was bloody is in fact that he was beaten. Another inference to drawn is in fact that he caused these injuries to himself. So the failure to report the assault...
He totally rejected that idea.
Well, he did, but my point is this. I'm not arguing with you that Gibson self-inflicted these wounds. That this was an assault by Doyle and Benson, period. But the failure to report the assault in this reference last paragraph here on page 32 of the appendix doesn't necessarily mean that involves eye contact.
No, I understand that.
It could be not reporting the assault by seeing an hour or so later that in fact this person is bloody.
I understand that.
So I started this by saying you cannot fault Upton for not writing a report for something he did not observe. I stand by that. If there was a factual finding here by the arbitrator that in fact Upton witnessed this assault and never reported it, this would be an easy case, I believe, for you to decide. That is missing, and you cannot sit here respectfully standing in the shoes of the arbitrator or reviewing this in a way of we must extrapolate from what the arbitrator has to say, and therefore we have to infer this. You have to look at exactly the findings made by Canavan. And there's nothing in there.
Could you just remind me what Mr. O'Rourke, where Mr. O'Rourke was?
Mr. O'Rourke was the physician's assistant who the victim Gibson was taken to upon Officer McCollum's relief of Upton.
Don't you think in the two appeals court decisions that the appeals court, and I agree with you, what matters is what does the arbitrator find, but the appeals court seems to infer that the arbitrator found at the least Officer Upton was in a position to see?
This appeals court infers, I believe, not that Upton was in a position to see it, but that Upton was present, possibly, for this activity. Now, we don't have, because the sheriff has not produced, schematics of the jail which might indicate where Upton was standing and what he could see when he was standing there in his post.
Well, what are we to make, for example, that apart from the issue of time, right, that the versions of other inmates show no material inconsistencies?
I'm sorry, Your Honor.
Show no material inconsistencies. I mean, isn't that what I thought that's what the appeals court was relying on. In other words, there's some inconsistencies about time.
Sure.
The arbitrator concludes that there was a failure to file a report of the assault.
Correct.
And so you can look, and he's saying that other than the little inconsistencies about time, the versions of the other inmates are all the same. Can we not conclude that the arbitrator is crediting them?
No, I don't believe you can conclude that. I believe what you have to read from this is simply that the arbitrator is reiterating exactly what the inmates said to him. He's not concluding that one is more credible than the other, or he's not giving weight to these statements as compared to what Upton did.
Why would the arbitrator have found, in this sentence, nor do I find that he could have stopped the unanticipated attack which occurred so swiftly? Why would he have made that finding if he wasn't also implicitly finding that Upton saw the attack?
Because Upton could have been present for the opening of the cell, standing in his control booth or in some position on the floor, seen the cell door open and see nothing else.
It couldn't be that Upton wasn't there, that he was off on some break.
Interesting enough, in my review of this for the umpteenth time, I thought I was convinced that, in fact, Upton must have been present for this activity. Maybe he didn't see it, but he was present enough to open the cell door. I don't know if you can conclude that now exactly by reading from Canavan's findings, because he seems to, without saying that Upton was present, he seems to go on and say, well, he opened the cell door. Therefore, you must conclude that he was present. I
He
think,
opened the cell door for these two particular people.
no, it doesn't, there's no finding for that, with all due respect. The only finding about a cell door being opened by Upton is at the 7 p.m. recreation release of the inmates. That's the only finding, and that would have been after the attack.
Thank you, Mr. Pfaff.
Thank you.